Hi, welcome back to the program as we celebrate Democracy Day. Although we're in the COVID-19 era, we've looked at different segments, the economy, we've looked at health, we've looked at our politics as well. And now, as Ladi said, we're looking at the law, the meat in the sandwich, technically, that binds all this together. Where would we be without it? And we're looking at it for the last 21 years of this democracy or so. Be part of the conversation as we asked you to be. And Ladi, I'm going to go to you now.
Indeed. A star-studded panel. I only hope that we get enough time to fix all the questions in. Starting from our Abuja studios, where we're being joined by the Minister of State for Labor. He's a lawyer, senior advocate of Nigeria, Festus Keyamo. Nice to see you, Mr. Keyamo. Welcome to the program.
Thank you for having me.
And in our Lagos studios here, we have first, in no particular order, Mr. Mohammed Bolgore Jr., Senior Advocate of Nigeria. Thank you for joining us.
Thank you.
And sitting beside him, we have Mr. Seni Adio, who is also a Senior Advocate of Nigeria. Thank you so much for being our guest this evening.
It's a pleasure.
And then you have, of course, the former Solicitor General of Lagos State, Director of Public Prosecutions at the time, Mr. Fola Athawari. Thank you so much for being with us.
Pleasure.
Let me start off with you in Abuja, Mr. Keyamo. COVID has brought about some innovation. I wouldn't say that innovation has been around for 21 years. It's been around for the last 4 or 5 months, which is the issue of virtual court proceedings. Many people have hailed this, but there are others who are saying, again, it's going to move justice away from those who do not quite have the means. Where do you stand on this?
Thank you very much. There are 2 issues involved here. The first one is the legal issue, whether the virtual hearings, they do satisfy the provisions of the law. And then the other one, of course, is the matter of convenience, how convenient it would be for people who are interested in proceedings, how convenient it would be for them to be part of those proceedings. But then the first one is that the only requirement the major requirements that we have regarding court hearings is that they should be done in public, except in certain trials where by leave of the court, certain witnesses should be heard in camera. So generally, the general principle is that trials must be held in public. Now, the provisions, to my mind, the provisions regarding the new rules regarding virtual hearings will satisfy that provision if, for instance, the link to those hearings are made public. You know what they do with the Zoom these days. They give you the number, the code to get into the hearings. And so if they are publicized in a way that members of the public can key in at any time from the comfort of their homes and watch the proceedings by Zoom, then it does meet that provision of the law. In other words, the public is allowed at any time through virtual means to join and observe court proceedings. So to my mind, the virtual hearings would not breach provisions of the law.
Let me follow up that question by asking a broader question now, which has to do with the issue of technology in the legal system and how that relates to the speed of justice dispensation. So many people have over the years talked about introducing technology, but somehow it hasn't gotten done. Given where we are now with all the rules that the health pandemic has brought about and so on, is this, in your view, more or less a compelling factor to introduce technology generally across the legal system?
Let me say, first of all, that I don't want to use the word that I'm happy that the pandemic happened, but I am happy that it is moving us faster than we should move, especially in the third world country, like Nigeria. In many parts of the world, filing of pleadings, filing of papers in court, and so many things have been done, and are being done by technology. We depend so much on hard copies here. We must take hard copies to court. We must file hard copies. We must bring hard copies to court sittings. We must even submit, in many cases, our hard copies of law reports that we cite. Many times the judges will tell you to leave your hard copies behind for them to write their rulings and their judgments. So there has been efforts in the past to move us forward faster than we were moving, so that we could use technology to drive court proceedings. But I'm happy that the pandemic is I'm not happy the pandemic came, but I'm happy that the pandemic has forced us to move faster than we were moving. And so I think it was high time, even before the pandemic, I think it was high time for us to do so many things technologically in courts. For instance, the filing of papers, there's no reason why you cannot file papers from the comfort of your offices. There are so many provisions by which we can pay online now. We pay our DSTV online, we pay so many bills online. So there's really no reason why we cannot pay court fees online from the comfort of our offices. Prepare your pleadings, file them online, and pay your fees online. So I am happy that we are moving faster than we should have moved, and I'm happy. I hope that we'll keep this momentum, even if COVID goes tomorrow. I think we should keep this momentum going in terms of the shift from, manual practice to technological practice.
Okay, Mr. Kayamo, I mean, technology and the law is just one aspect, but looking at the rule of law itself in the last 21 years, what I'd like to know is how you think we have fared in terms of that rule of law, just beyond that technology and how to speed up the process. You've been on both sides, and you know what I mean by asking you that. How have we fared in terms of the rule of law itself?
Well, it has been a mixed bag, the rule of law, in the sense that it is expected that in a third world country like ours, or an emerging democracy, more or less, we are yet to test many aspects of our laws and our democracy. So we have had to wait for the Supreme Court to interpret most of our laws, interprets many provisions for Electoral Act regarding human rights, regarding the right to vote, right to contest, right to various offices, for us to determine the slant, the correct slant of the law in many cases. So whether we have complied with the rule of law or not depends on the angle from which you are looking at it. For instance, there was a time when, without the Supreme Court intervening, we saw 6 lawmakers removing the governor from office. And the bar was divided. Some said, no, well, it is 6 sitting, and then we only have to look at the required number from the minimum number that can sit. And some people say, no, we could only look at the numbers that can remove a governor from the whole house. The number of the whole house, until the Supreme Court interpreted it. So at that point, when the regime used 6 lawmakers to remove a governor, we all shouted the rule of law was being bastardized. Some other people say no, they were within the law. So in other words, the rule of law is an emerging issue. As the Supreme Court continues to interpret our laws, and as we go on, the laws and the correct slant and color of most of these provisions would become clearer and clearer as time goes on. But overall, we are happy that we have sustained democracy for 21 years. We are happy that the judiciary has kept democracy alive, because in all of this, in many cases, if left to only the two other branches of government, perhaps democracy would have collapsed long ago. But the judiciary has stood its grounds. The judiciary has restored democracy in many instances, has intervened decisively in many instances, and it has kept us going.
Thank you very much, Mr. Kayamo, for that. We want to thank you this evening for joining us on the program. Thank you so much for your time. Mr. Festus Kayamo, Minister of State Labor, joined us from our Abuja studios. Now, expanding the discussion, I'm going to put the same question to 3 of you. When people talk about the law, essentially they talk mostly about law and order and getting justice.
Yes.
That's the end of the
Yes.
process, when people get justice
Yes.
and they see themselves getting justice. Have we seen more of that on that democratic rule than we had previously? Is that a fair comment?
Let's
Yes,
start with
that
you,
we
Mr.
saw
Warren.
more of that.
More of people.
Getting justice and being seen to get justice.
I think if we don't have records of actual cases where human rights claims were upheld, it's difficult to say. I think the picture is mixed. We've seen the courts try their best and some level of resistance sometimes from the person who should assist in the compliance. But I think we shouldn't narrow ourselves, I think, in terms of speaking about the rule of law, to just obedience to court orders, etc. We should look at the whole of society and see whether there's been the necessary behavioral change whereby people comply more. There seems to be a battle now to sort of impose order, as if people have taken democracy to mean I can do what I like. I think it's important that beyond the judiciary, we should look at the other institutions responsible for order, such as the police, and then citizen awareness, whereby, you know, compliance, normal societies would have a majority compliance, and then the systems will be able to deal with the deviant few. But we seem to be moving towards, I mean, if you look at the state of the roads and the way people drive, the way people behave, you go to institutions, they don't follow the regulations, you understand. You might go to the website of, say, some particular licensing office and they tell you, these are the steps, and you get there and then they say, well, there are more steps. All of these, to me, I mean, when you see, it's not just, that's why I say it's not just obedience. I mean, if you travel abroad, you're not even thinking of the courts. You'll see order. So I think that the burden of governance going forward is that by their example, they can force the type of behavioral change. You were talking about, when you were interviewing the general, you spoke about Army public relations. We know that invariably in 9 out of 10 cases, there's oppression, there's violence visited by, you know, the military people against civilians. And we're saying that democracy means that everybody beyond the judiciary, the leaders of the institutions that impact on daily order and a sense that there is indeed a rule of law are important players in this system. So I would say that the picture is mixed. That would be my
What would be your view?
Yes, well, I agree with Mr. Thawari, but I would also say that indeed there's been progress. I think that for example, in terms of civil litigation, the way we practice in our courts now, in terms of front-loading pleadings to remove the element of surprise, so that parties, when you're going to court, you know what your opponent's case is about. I think that's progress. So more recently, I think at the Lagos High Court, we have the new civil procedural rules. I think it's 2019. It's an advancement from the 2004 civil procedural rules. So you have that. You have some level of transcription at the High Court. It's not in all the courtrooms yet. You know, there's some progress. Mr. Kayamo mentioned e-filing. That's happening. Not at the level it ought to be happening. Maybe as a result of new practice directions that the CJ of Lagos State, Justice Alugba, issued about a week ago, maybe we're now getting to the level of actual virtual filings, because before you would still have to, I mean, they would scan the documents, but you still have to go physically to the registry to have it done. That's not really e-filing. So there's been progress. We have courts that are specialty courts, the commercial courts, but not just in Lagos. Various jurisdictions have commercial divisions. We have many of the courts now in different states have the mediation centers. For example, a lot of people are able to resolve their matters fairly expeditiously through that process. So there's been progress. But if I may just amplify on what Mr. Kayamo was saying, in terms of technology,
right?
You know, for me, I don't think it's an issue to be debated. I think the law is very dynamic. We don't have a choice. We have to move with the times. And in many jurisdictions, and I don't know why we have to be following what other people do. Why can't we be pioneers and be the first to do something? So, for example, the U.S. Supreme Court has been having hearings remotely already. In other climes, proceedings are being held, both civil, criminal proceedings, and judgments being rendered. Coming to our own continent here, there have been proceedings in particularly Kenya, for example, where judges are reading out tens or dozens of judgments in a day through virtual hearing.
But ours is a subject of litigation at the moment.
Well, apparently some states, some southwestern AGs have gone to the Supreme Court, but they've gone because they want clarity and certainty. They are for using technology. They just want the Supreme Court to make that pronouncement so that it's very clear to the other tiers of courts that, in fact, this is constitutional.
Mr. Bagori, how about at the administration of justice?
I wanted to. Sorry, I'm sorry. I don't think we should, though, adopt the view or the misconception that virtual hearing is proposed for all hearings. That will not work, because that, first of all, that won't deal with the backlog of cases. And secondly, normally you use it for emergency hearings where you need a quick outcome, or where a witness is in another country and it was expensive, or bail hearings, administrative hearings. But I think the substantial number of cases within the system will still go on in the normal physical, but with the enhancement of the technological backup, the filing, the ability to access cases, etc., etc. I think that's where we should be looking at.
Mr. Bagori.
I was going to ask about, going to ask about the Administration of Criminal Justice Act.
Yes.
Quite a lot has been made about that, particularly about the issue of speed and the introduction of delays by one or both parties that do not serve the interest of the law. How has that worked out? Because people still talk about delays.
Well, thank you very much. You see, delay is a function of a number of things. One is a function of the lawyers, it's a function of the judges, and it's a function of the rules within which they operate. The Administration of Criminal Justice Act has attempted to cut the delays. But as Mr. Athawari said, you've got to change people's attitudes. If you don't change the attitude, if you have new laws, but people are still operating with the same attitude, you're not going to get much in terms of progress. Also, we have to bear in mind the fact that justice must not be rushed. In an attempt to cure delay, you might cause injustice. The Administration of Criminal Justice Act says things like, there are certain applications that when you raise them, the judge does not have to decide them. He waits till the end of the case. Now, what I'd interpret that to mean is that the judge has a discretion to wait until the end of the case, not that he must mandatorily wait till the end of the case. But unfortunately, you get some mechanical interpretation of this in which the judge just says, nope, read what the ACJA says. I'll give an example. You come to a court and says that court does not have jurisdiction. And I've heard argument that before the court has to decide it right away. But the Administration of Criminal Justice Act merely says the judge can listen to the argument and then decide at the end. Now, if it turns out that it doesn't have jurisdiction, you've wasted the time of the court, you've wasted public resources, but more importantly, you've put somebody, and we must never lose sight of this, you've put somebody through the rigors of a trial, a criminal trial, when he should not have gone through a criminal trial. So we'll bear that in mind. But if I may just touch on something that my colleagues have said, and Festus Keyamo, without repeating what they've said. The rule of law is not optional. It's not a tool of convenience. You're talking about progress. And what is the rule of law in this instance? It is running the society in an orderly fashion based on the law. And what that means is that everybody is subject to the law. The highest person in government is just as subject to the law as your ordinary private citizen. So a situation whereby when it suits the powers that be, they obey court orders. When it doesn't suit them, they do not obey court orders. That, for me, is the biggest obstacle and the biggest drawback to the rule of law in the period that you
I understand we have to
mentioned.
go back to Abuja, but just before we do, Mr. Warri, just to ask you quickly, with the way things are going now, there have been calls for special courts. We know
In relation to criminal
No,
justice?
now in relation to another issue.
Okay.
Just quickly now,
Okay.
we know there were calls for special courts
Yes.
when we talk
Against
about corruption.
corruption,
Okay.
Now we're
electoral
looking at rape,
offences.
Yes.
and this is it's an issue that
Yes.
affects so many people.
Yes.
Where are we on that? If the courts were doing what they ought to do,
Yes.
will we be looking for a special court for
I have
that?
never been a believer in special courts for special. Let all courts run efficiently, and then you have the divisions, and rape or any other criminal case will fit into the criminal division, be resourced properly, will not tolerate the disassembly that we tend to use, and will achieve the same results. What you do, set up special courts. That's creating more expense. Then oftentimes you take judges from the regular circuit, because you can't just appoint them overnight, and you bring them into the special courts and generally disrupt, in my view, the administration of justice. So I think it's better to have overall efficiency in the system that can deal with any matter, rather than shifting and adjusting, to deal with specific. Rape is a crime that's been with us for a long time. The internet, and there have been many convictions without special courts. But then I suppose it's a matter of policy, and that the objective will be that anybody involved will be punished adequately and within such a reasonable time as that the judgment will have an impact, because the judgment is supposed to act as a deterrent. But if you are extending a trial 3 years after the witness, everybody's forgotten, then it becomes a mere technical exercise. The purpose of a criminal conviction is principally to deter. Even you punish
Somebody else who's thinking
Yes,
about, or
who's
maybe thinking about
it.
it.
That listen, within 3 months you'll be in prison for life. That makes sense.
I need to ask the two, before we go to Abuja, I need to ask two of you the issue of personnel, because that's the other side of this that very often doesn't get addressed. A couple of days ago, there was the argument that the Supreme Court has 12 justices. It ought to have 21.
21, yes.
Okay? And 4 names had been submitted, working their way through the bureaucracy. The issue of personnel, how vital is it to the enhancement of the processes the three of you have described earlier on, the issue of personnel?
Well, to answer the question, it's very vital to have a full complement on the Supreme Court. Equally vital, perhaps even more vital, is to have the right complement, if I may describe it as such. By that I mean that to have diversity in terms of what the personnel bring to the court, so that, for example, having members of the court who have been in academia, for example, having those who have spent a lot of time at the private bar, for example, that's happened in the past. So I'm certainly in favor of appointments from the bar. I'm also in favor of appointments from the academia. And then certainly with the 4 that are pending, the 4 Honorable Justices of the Court of Appeal that are pending, yes, I would advise that the government should promptly have them sworn in and then come to as close as possible. I'm not sure we've ever had a full complement before, but I think at least come as close as possible to having a full complement, but including people in academia and from the private bar.
Mr. Belgari, what do you think?
Well, aside from that, that's a very vital issue. But I think that's just a symptom. That's not really the cause. You've got to look at how the Supreme Court is structured today and what it does. The Supreme Court is the highest court in the land, but it takes appeals that originates from the very lowest courts. A landlord and tenant dispute over a rent of 5,000 naira still gets to the Supreme Court. There's no reason why that should be the case. And as long
we're completely out of time. We're completely out of time. I believe that your point is well observed. We'll have just about 30 seconds to take the final word. I understand the Minister of State for Labor, Mr. Festus Keyamo, is still in our Abuja studios. Mr. Keyamo, you've listened to everything that's been said. 30 seconds, summary, please.
Let's take it from what the last speaker was saying. Very simple. If we want to hasten the dispensation of justice, we should make sure that we do adopt recorders for our judges. It is too antiquarian for judges to still be taking proceedings by longhand. That, I think, is the key that will unlock a lot of these delays in administration of justice at the lower courts. At the Supreme Court, we need to decentralize the Supreme Court. We need to do that. If we don't do that, we're going to have backlog of cases for 10, 15 years waiting for the Supreme Court to be heard. Thank you.
All right, then it's at that point that we're going to leave it. Like every other thing and like every other segment today, time has not been our friend. So let's thank Mr. Athawari, Mr. Adio, Mr. Belgore, and of course, Mr. Keyamo in our Abuja studios. Thank you, gentlemen, for coming in. These discussions will continue endlessly on other platforms. But Ijoma, it's time to go.
That's indeed. Thanks a lot for joining us. It has been a nice one, hasn't it, Ladi?
Indeed.
Happy
My other problem has always been time. So I guess
what do you do when you have 4 essays?
I mean, you've got to take your time with it.
Yeah.
So it's time for us to go. We thank you so much for being with us right from the start as we took you through all the discussions today. Do have a happy Democracy Day. Enjoy.
Yeah, great. And bye.
Bye-bye.